Thank you very much. Please be seated. Thank you both for joining us today. This is the time set for oral argument in Wilkes versus Monabianco, our cause number 1CA CV130216. Let's begin with introductions of counsel. Sir?
Mick Levine for the Wilkes family.
Welcome.
Thanks.
Good afternoon, Miles Hassett for defendants at Monabianco at State Farm, in the courtroom. Monabianco and his wife, Sam.
Great. Thank you very much and welcome. Let me go through a few preliminaries. First, let me advise the parties and their counsel that we have reviewed carefully the briefs in this matter and the record as pertinent to the arguments today, so we're familiar with the basic facts in the matter. Each side has 20 minutes. If you would like to reserve time for rebuttal, you'll need to watch the clock, but if you go to the podium and tell us how much time you'd like for rebuttal, we will try and not ask you so many questions that we eat up your time. We are recording these proceedings today, both video and audio, and so when you go to the lectern, even though we know who you are, if you wouldn't mind, please restate your name. That way, if we have anyone who would like to view the recording, they'll know who's speaking. So with that, let's go ahead and begin.
Thank you, Your Honor. May it please the court, my name is Mick Levine. I represent the Wilkes family. First and foremost, I want to apologize to the court, staff, counsel, and his client for my absence last time.
We appreciate that, and thank you.
I want to start by talking about insurance agent. Insurance agent owes a duty to two particular people. In this particular case, they owed one to the Wilkes. They also owe one to the insurance company. Now, we know from Darner Motor Sales that an insurance agent owes a duty of care to the Wilkes. That duty of care requires them to perform with reasonable care, skill, and diligence in carrying out their duties. Their duties in this particular case are defined by our expert, Mr. Spector. Mr. Spector says his duty in this case was to acquire the insurance that the Wilkes family requested. The Wilkes family requested the insurance. He needs to provide it. So what did the Wilkes family request? We have the Wilkes family's deposition of Mrs. Wilkes. She says in her deposition that the Wilkes family, they had they had UIM back when they were in New York. They moved here to Arizona. They met with somebody from the Monabianco agency. They said, we want UIM, and the amount of $100,000. That's what they got. They stayed with State Farm for a while, but after being with them for a little bit, they went to a different insurance company. They were only gone a few months when they came back. They said, we don't like the old insurance company, we want to come back to you. We'd like the same insurance that we had before. That's a request for the same insurance that they had before, and that's what Mr. Monabianco's duty was, to acquire the same insurance that they had before for the Wilkes family.
What about I believe that Mrs. Wilkes testified in her deposition that she actually, the policy that she received varied in at least two instances, one involving, I think it was rental car coverage, and I think also medical expenses. So she really didn't get what she, under her testimony, asked for. Does that make a difference here?
Not as far as what the request was. The request here, as she testified, was that she asked for the same insurance that she had before. She didn't get it. We acknowledge that. There were a couple of differences between her old policy and the new policy. I believe that there was a deductible change. There was also the dropping of this UIM coverage. But what her request was the same coverage that she had before. And that's what Mr. Monabianco and his agency needed to provide for her. And we know that they had the ability to find out what she had before. Mr. Monabianco, during his deposition, said, yeah, we can look that up. We just don't usually do it that way. We do it a different way. Nevertheless, what happened in this particular case was that he didn't acquire the insurance that was requested. Instead, he obtained liability coverage in the amount of $100,300, UM coverage in the amount of $100,300, but no UIM coverage. Now, the UIM coverage comes into play here because Mrs. Wilkes got into a car accident. She was injured. The other insurance company tendered their $15,000 policy limit, and she wanted to make a UIM claim. Only she couldn't because she didn't have that insurance. The reason why she didn't have the insurance, again, it's because the Monobianco agency didn't provide the same insurance that she had before, which is what she had requested. Now, that's duty, breach, causation, damages, just in a general nutshell there. I understand that the defense has some arguments that they're using in order to say, well, we got a waiver. The waiver that they're talking about is this waiver pursuant to ARS 20259.01b. Now, that waiver is good for the insurance company. The insurance company themselves, they're not responsible once they get that waiver. And we've got a lot of cases that tell us that once the insurance company has that waiver, or even if it's just sent to the insured and the insured has the opportunity to buy that insurance, the insurance company isn't on the hook anymore. And we've got Talent, we've got the Blevins decisions, we even have Ballesteros.
Isn't the point of that legislation to avoid kind of an after-the-fact determination? Why shouldn't it also apply to an agent? Let's sorry to be so long-winded here, but let's take away the I specifically asked for what I had before, and we're just in a situation where you're meeting with an agent, and I want automobile insurance, and there's no discussion of UIM or UM coverage. Does the statute protect the agent under that set of circumstances?
I can't answer that question, and because there's no case law on that question. What I can tell you is that the statute doesn't say insurance agent anywhere in it. I can also tell you that if the legislature wanted to immunize insurance agents as well as insurance companies, the legislature could have said so, but they didn't. What I can also tell you is that an insurance agent owes a duty not just to the insurance company, but also to the insured, the person who's buying the insurance. The person who's buying the insurance needs to have this conversation with the insurance agent about what it is that they want. And the insurance agent has a role here with the insured to exercise reasonable care, skill, and diligence in carrying out that person's wishes. So when you're talking about, well, does this waiver in and of itself, if an insurance agent gets that signed, is that enough to immunize the insurance agent for any liability for not having talked to their insured about maybe UM or UIM might be a good idea? That depends upon what an expert's going to say an insurance agent under those circumstances should do for their customers.
What about State Farm's argument that by allowing this claim to go forward, the court would essentially be sanctifying an end run around a long body of case law, you mentioned some of them, that basically interprets the statute as providing an insurer a safe harbor. Because under principles of respondent superior, this is just another way to get around that and get to the insurance company.
I can't answer an end run around the statute in order to get to the insurance company because, quite frankly, I don't know what the relationship is between the insurance agent and the insurance company in all situations. I know that there are independent insurance agents out there who don't have an insurance company that they're employed by or that is responsible for them. But what I can tell you is this: even in a case, let's take Ballesteros for example. As I understand it, the insured in that particular case didn't speak English, didn't understand the form that they were given, had no idea what UM or UIM was based upon the form. What we're saying here is that an insurance agent, if an expert says it, has a duty to do something with that particular insured. If the expert indicates that when exercising reasonable care, skill, and diligence, the insurance agent should explain to Mr. Ballesteros, in this particular example, what that form means in such a way that Mr. Ballesteros could understand it, then that's what the standard of care is, and that's what an insurance agent needs to do.
What's the point then of having 259? If we lived in a world where there are no independent agents, it's just the insurance company has employees who are selling the insurance. I mean, isn't the point of the legislation to try to avoid after-the-fact determinations? Even in Ballesteros, we're even though there's an allegation that the insured doesn't speak English, it wasn't the point. We don't want to go through this as long as the insurance company has provided this document that explains what UIM and UM insurance is. That's all we need to do.
I want to challenge your assumption there for a moment. If we didn't have independent insurance agents, does that mean that one insurance agent is different than another one in some way, shape, or form? That an independent insurance agent owes a different duty to an insured than a captive agent?
But what I'm trying
not
to get
sure
at is
that I
what-
necessarily agree with that.
What I'm trying to get at is what has the legislature accomplished with 2259?
They've made it so that as long as the insurance company offers the insurance to the insured, the insurance company isn't responsible. That's what the plain language of 2259 is
So
that
it's just a question of not wanting these parties as opposed to we want to kind of avoid litigation.
as far as the intent of the statute goes, I can say that it doesn't want these parties because that's what the plain language of the statute says. It says that an insurance company isn't responsible so long as they offer the coverage. It doesn't say anything about insurance agents.
But don't they offer that coverage through insurance agents? I mean, how else is it offered?
I can call up Geico and talk to somebody who's
Fair enough.
there.
But in a lot of instances, it goes straight through the agent.
And in a lot of instances, it does go straight through the agent. But you see, the insurance agent has this duty to their client that's separate and apart whatever the insurance company owes the client.
And I understand that, but if the purpose of the statute is a safe harbor for insurers, as long as they offer this, and at least for some substantial number of transactions, the only way it's offered is through an agent. It's sort of an odd result, isn't it, that the agent, it has no application at all to the agent?
Well, I think that brings me to another point that I was wanting to make, which is the Jamerson versus Quintero case. Just because we absolve the principal doesn't mean that we absolve the agent. The agent still has liability and responsibility separate and apart from whatever the principal has. So what we're talking about here is we're saying, look, we're going to let the insurance company off the hook. The legislature is clearly stating we're going to let the insurance company off of the hook. But why might that be is because the insurance agent has more of a relationship with the customer who comes in than the insurance company. And when this product is offered, whatever it is, car insurance, homeowners, whatever, when it's offered to an individual, it's offered through the agent, another individual. And those two people are supposed to have a conversation about the needs and requirements and what have you of the person who's purchasing the insurance. Now, the insurance company, they're distant to that transaction. They're not actively involved in that transaction. Yes, it has to come through an insurance agent, but the insurance agent has more knowledge than what the insurance company does.
Would your reading of the statute, how would your reading of the statute treat a contract claim against the agent as opposed to a tort claim? Or does it matter?
As far as 2259 applies to a contract claim as opposed to a tort claim, I haven't really thought about that, but I would say that in tort, the insurance agent owes a duty of care to the person who's purchasing the insurance. In contract, the insurance agent would have a contract with the person who's purchasing the insurance and whatever that might entail.
And they could have contractual duties. I mean, I guess
I agree.
Is your argument at its essence that this statute, no matter what the claim is, if it's a claim against the agent, just has no bearing to any part of that claim?
If it's a claim against the agent, I would agree with that, yes.
Well, no, and I'm asking whether that's your position.
Yes,
Okay,
that's my
all right.
position.
So if we have these same facts, absolute same facts, and I recognize State Farm was at one time in this case, but let's assume that they weren't in for in this case.
Okay.
Hypothetically, same facts, but here, a direct employee of the insurance carrier had the communication. Is it your position then the statute would bar the negligence claim against the carrier at that point?
A direct employee, not an insurance
An
agent.
insurance agent, but I mean, this is the little Geico, or I don't mean to pick on Geico, but this is a company that does not have agent. It has employees, and you call the company directly, and they will write the policy while you're on the phone.
Under those particular circumstances, I would have to say that's an employee of the insurance company and not an agent who owes a duty to a customer. That instead is somebody who's answering a phone and filling an order.
The statute
So I would agree
bar-
with that.
The statute would bar the claim.
I would agree with that. Thank you. I'll reserve the rest of my time.
Thank you. Good afternoon. Miles Hassett for State Farm and insurance agent John Monabianco. Let me go back to a question that Judge Kitani asked, because I think it's the pertinent question. What has the legislature accomplished by enacting ARS 20-259.01? What the legislature has accomplished is certainty. The legislature, in amending the statute in 1992 to provide for a form which, if used, would be valid for all insureds, has accomplished a degree of certainty in an area where there previously was none. If the court goes back and looks at the cases that predate the 1992 statute, you'll see the following. You'll see the Gilley case from a different division of this court, which indicated that the insured's misunderstanding of the transaction or lack of comprehension regarding the offer of UM and UIM coverage could potentially be a fact question of sorts. The legislature responded to that, and this is clear from the court's analysis in Ballesteros. The legislature responded to that by inserting the language that permitted the use of the Department of Insurance approved form. And there is no mistaking the language in the statute. The statute says that where the approved form is used, the selection or rejection of coverage, this isn't a waiver, the selection or rejection of coverage shall be valid for all insureds under the policy. Shall be valid for all insureds under the policy. There are no statutory
I take it your
exceptions.
position is that it does not matter what the alleged negligence is at all, is that this provides an unequivocal, categorical safe harbor.
I agree with that. This is not immunity as the other side asserts. This is statutory protection for an insurance agent doing the job that has been delegated to him by his insurance company
Let me
principal.
give you a hypothetical. Let's say that in this, again, this is a hypothetical. I know they're not the facts in this case. But insured goes to agent and says, categorically, I want uninsured motorist coverage. And the agent procures the policy, and through a mistake, instead of uninsured, the insured is given underinsured motorist. Okay? So they asked for A, they ended up with B. And of course, you know what happens. They get hit by someone who's uninsured, not underinsured. And the insured then pursues a negligence claim. You're saying that this statute would bar that claim?
Well, let me just ask for a clarification, Judge Norris. Has the agent in your hypothetical used the form? And
Yes, use the form. Absolutely use the form. Everything else is the same.
And does the form reflect the...
It has the little boxes and the little check marks, the whole shebang.
I understand that, but here's my question. Does the form reflect what is eventually placed on the policy? That is the rejection of uninsured motorist coverage, the acceptance, let's say, of underinsured motorist coverage.
The insured says, I want A. The form inadvertently makes the wrong check marks. The insured doesn't read it. The policy comes and the insured gets B instead of A.
Yeah, that's a problem for the insured, because when you look at the form has a signature block signed here by Mrs. Wilkes, and right above it there's a statement that says, I have read and understand the
But
form.
in Darner, I think it was Darner, our Supreme Court basically said it doesn't much matter if the insured doesn't read all of this material. That just raises an issue of fact.
Yeah, and well, Darner's different with all due respect. Darner concerns whether the insured read the policy, and the court says the insured doesn't necessarily have to do that. There's no other example in our legislation in Arizona that I can think of where The legislature has said that if you use this particular form and it is offered, and in this case signed, by the insured, that it shall be valid for all insureds under the policy.
What about, and I know it's not argued here, but doesn't that, to the extent that you have now raised a categorical position that you've taken in this case, doesn't that present a possible problem with Arizona's anti-abrogation provision or Constitution?
Well, I am not saying that there might not be cases where the form or the agent's use of the form might not be open to question, but I don't think that they are presented in straight negligence cases. I could think of a case in fraud where the agent behaves fraudulently and there's some kind of bait and switch.
Yeah.
I don't think that the statute precludes that, but I do think that it precludes claims against agents who are discharging their duties in the ordinary course of serving the insurer's business. And to the point raised earlier by the court, the agent, and I think this was Judge Thuma, the insurer can only act through the agent, and that's particularly true in the case of State Farm. State Farm only has captive insurance agents that sell State Farm products. So for the statutory protection to mean anything for State Farm, it must, of necessity, also apply to the agent.
But why is that? Because if there is liability, the agent will be responsible. It's not going, I guess if the agent here wanted to sue State Farm, then State Farm says, hey, you're the one who didn't provide the cover or procure the coverage. We provided the coverage that you asked us to provide, and there's just no liability here by State Farm.
Well, except that in every case where you see this, the claim is that State Farm is vicariously liable for the agent's alleged conduct.
But there's not one case that you've cited that has held that. The only case that comes the closest actually went the other way, in which the insurance carrier asserted a claim against the agent for not meeting the requirements of the statute.
Right, and that's the Miller's Mutual case, Your Honor. And what Miller's Mutual points out is that the agent is in a double bind, because if the duty is delegated to the agent to make the offer of coverage, the agent is certainly liable to the insurer if the agent doesn't do it properly. That's what Miller's Mutual says. And the agent had to indemnify the insurer when the agent didn't make the proper offer. Well, if that makes sense, and the agent can be liable where the duty is delegated, it makes absolutely sense for the reciprocal to apply, which is that the insurer ought not to be liable where the agent does what the agent is required to do.
I think what causes me the most difficulty that I'm just struggling with is that the statute speaks in terms of every insurer writing automobile liability policy.
Yes.
And the history that you have summarized, which is set out in Ballesteros as well, has been an effort by the legislature to protect the insurance company. And I don't know of any case that has applied this statute to protect or to provide a safe harbor to an agent where the allegation is that the agent did not procure the product that was requested.
Yeah, and I don't think there is a case directly on point, which is why we're here to discuss this case. If I had better,
You make it easier for us.
you know, if I had better law, Your Honor, I would certainly offer it to the court. But what we have done in the brief, and what I'm saying to you today, is that there's a long history of law on this statute, published and some unpublished too, which deal with a whole range of issues. What you will not find in any of that jurisprudence is a case that accomplishes what the plaintiff wants to accomplish here, which is an end run around the statute, something that undermines the form either through use of an additional term. This court recently published its opinion in the Newman case, refusing to read a term into the statute concerning price. If the court goes back to talent and looks at the guidance provided there, the hope being expressed that disputes of this kind, the after-the-fact type disputes that Judge Catani referenced, would not arise in the future, look all the way back to 1990, and from 1990 forwards to this date, there is no published case that supports the idea that the form is somehow defective and not enforceable simply because it is used by the agent of the insurer as opposed to the insurer itself. And even a close reading of Ballesteros discloses that there was an agent involved there. The court observed that the agent there was in a position potentially to speak Spanish, but nonetheless used an English language form with a Spanish-speaking customer. And even though it sounds like a harsh result, the court determined that the Spanish-speaking customer who had signed the English language form, like the form here, was unfortunately not entitled to question the coverage. And
Didn't Ballesteros, though, in a footnote, sort of carve out the tort claim, saying those aren't before us, we need not apply them?
yeah, that is the narrowest possible exception that I can think of, Judge Thuma, because it concerned only the idea that an agent who knew that the insured didn't speak Spanish and didn't understand the form might have a tort obligation to somehow use a Spanish language form. And I believe that a close reading of Ballesteros will bear that out as far as what the exception that the court carved or potentially carved in that case. It was not, and let me just quote Ballesteros for a moment, because I think this is the important point here. This is 226 Arizona Reports at 350. It's head note 10 in the case. So, although Section 20-259 is remedial in nature, we nonetheless conclude, as we did in Talent didn't have a language issue, as we did in Talent, that imposing a comprehension requirement is both unwarranted by the statute and unwise. We further recognize that the legislature passed the 1992 amendments to protect insurers from after-the-fact inquiries regarding the offer of coverage.
But there's that pesky word, to protect insurers.
Yeah, I understand that, and I want to address as directly as I can your concern. You know, if the statute is to have any meaning at all, then it ought to apply to agents who are doing the insurer's business. Otherwise, the court will put us back into a pre-1992 scenario where every transaction that is conducted by an insurance agent in offering the coverage, and this happens hundreds, maybe thousands of times a day in this state, every one of those transactions is then subject to after-the-fact guessing and after-the-fact inquiries of the kind that were discouraged in Talent and in the entire line of cases that followed. So the issue, according to Ballesteros, cannot be comprehension, meaning I didn't understand what I was doing when I signed the form. Because
I guess that's where my next question comes up. If you limit Ballesteros to whether you understand that the availability of UM or UIM, I mean, could we limit it that way? If Ballesteros has carved out or has in that footnote just saying we're not addressing these other claims, we're clearly not addressing fraud, and I think you've agreed now that if there's a fraudulent, some sort of fraudulent conduct on the part of the agent, that would not be protected under the statute. But isn't what happened here a bit distant from the we have available UM and UIM coverage, this is what it is, accept it or reject it? Isn't this different when we say, I specifically want $8 million worth of coverage, and then if the agent just mistakenly says, just gives them a form that only provides $1 million of coverage, is that different than we're trying to accomplish with the statute? Sorry for the long-winded.
No, and I think I do understand the concern, but let me try and address it this way. The form is an approved form for a reason. The statute doesn't say disregard the form. The statute says pay attention to the form because what the insured has done is make a valid selection or rejection of coverage. Now, are there possible mistakes within that context, within the buying and selling process? I'm sure there are. This transaction happens hundreds, maybe thousands of times a day. But the reason that there's a statutory scheme is for certainty, not for uncertainty. And going behind the statutory scheme promotes that degree of uncertainty that the legislature and all of the prior cases on this issue have found unacceptable. And
so you would go behind it, though, for fraud?
Well, I agreed hypothetically with Judge Norris that a certain kind of case not presented here might somehow in the future present a possible basis upon which the validity of the form could be questioned. And I would liken that to a possible fraud. So I am not going to say to the court that I think this is absolute and for all time. What I'm saying is that here we've got a straightforward negligence allegation against the insurance agent in the sale of coverage where the agent uses the statutorily mandated form and obtains the insured's signature. For sure, the agent leaves that transaction with the understanding that is cemented in the form. And if the insured has left with a different understanding, I'm sorry to say, but the legislature has made that the insured's problem. And it is the insured's problem because they have received the mandated form, they have signed it. Look, the form says, I have read and I understand the above explanation and offer of uninsured motor vehicle coverage and underinsured motor vehicle coverage. I also understand that I have the opportunity to ask for additional explanation from my agent. In her deposition, Mrs. Wilkes conceded that she understood the language of the form, but that she certainly had asked no questions of
But why
Mr.
shouldn't that just be
Malabianca.
something that's resolved through a trial? That would be very powerful evidence for your client to present. And if she has something that approaches fraud, then wouldn't that be a factual issue for the trier of fact to resolve?
Well, you're trying to talk me down from my fraud ledge now, Judge Catani, but and I'm not particularly interested in that, although I want to respond to your question, which is, look, I'm back to the element of certainty versus uncertainty. Your question says, look, why isn't this a fact question and these kind of things should go to the jury? Well, there's a reason for this being a dispositive issue, and it's because this court and the Arizona Supreme Court has actively discouraged after-the-fact inquiries into the circumstances at the point of sale. That's really what this is about. The form eliminates, the use of the form eliminates the prospect of after-the-fact inquiries of a routine or general nature, such as the kind of negligence that's asserted here. That's what's discouraged by the statute, and I would argue that is what is not permitted by the statute. The legislature could have carved all kinds of exceptions to this statute, but they didn't. I think that I have addressed the questions concerning the agency, but does the statute extend to agents? Our argument is that for it to mean anything, it's got to extend to agents. Insurers, or this insurer in particular, State Farm, only does business through its authorized agents. And so if you determine that somehow the statute is not applicable to State Farm agents, you have then opened State Farm to those very claims that the statute was designed to preclude. So let me just conclude by saying, and I'm obviously happy to take additional questions, but let me conclude by saying that there is over 20 years of precedent supporting the result that we seek. I recognize, Judge Norris, the concern that agents are not singled out, although they are a factor in those other cases, including in Ballesteros. But the fact that the agents are not specifically referenced in those cases doesn't mean that they are not entitled to the statutory protection when they do their job.
I guess what I would be more persuaded by is if there's anything that goes to a claim other than a breach of contract claim. If there's any, I'm a little bit troubled by the Ballesteros carve-out in the footnote, where it seems to suggest we're not addressing negligence, breach of fiduciary duty. This is a breach of contract claim against the insurer.
Yeah, well, of course, it was the Supreme. I was in Ballesteros, and it was the Supreme Court's prerogative to decide the issue that they wanted to decide. And so I don't know that I can answer that, except to say that if this is past the parcel, then I guess here we are. But
Those pesky Supreme Court.
well, I have the greatest of respect, of course, and
Of course,
I
we
mean
will,
no,
all of us do.
I mean no disrespect by stating anything that I did about the Supreme Court. It would be good if they had answered the question, but we're here today to get hopefully an answer to that question, and I strongly encourage you to think about upholding the validity of the statutory language, because it does say shall be valid for all insureds under the policy. There are not exceptions listed in the statute, and this is not the case to begin carving out an exception on these facts. Thank you.
One point that opposing counsel made was that there aren't any exceptions in 2259. We don't need one. It doesn't say insurance agent in there anywhere. If it said insurance agent in there, then we need an exception. But it doesn't. Now, the way that I understand statutes is that they're supposed to say what they're supposed to say, and they're supposed to mean what they say when the legislature goes about passing these things. If they wanted to put in insurance agents, they certainly know how to put in insurance agents. Why wouldn't they put in insurance agents is a good question to ask. And that's because an insurance agent owes a duty to a customer as well as the insurance company. Does the insurance company owe a duty to the customer to make sure that they get the right insurance, the insurance that they requested? No. But an insurance agent is a professional. Like a lawyer or a doctor or anybody else, they have a standard of care that they have to live up to. And the standard of care that they have to live up to is to take reasonable care of their customers. And that's what's reflected in the testimony of our experts. When somebody comes to you and asks for insurance, you have to give them the insurance that they've asked for. One of the questions that I think we were talking about a little bit with opposing counsel was, what about this waiver? They signed this thing. And I believe, Judge, you pointed out that there might be circumstances where something got switched purely by accident, or somebody didn't read the waiver or whatever. That comes out of the Phelps versus Firebird Raceway case. In Phelps, what happened was that there was a waiver of responsibility. There was an accident, and the guy wanted to sue anyways. Constitution says that the defense of contributory negligence or of assumption of the risk shall, in all cases whatsoever, be a question of fact and shall, at all times, be left to the jury. So isn't it up to the jury to decide whether or not Mrs. Wilkes read that form, whether or not there were extenuating circumstances why she didn't? We know we have the testimony. She was there with her kids. She was had a sheaf of papers. She signed them all. She didn't read any of them. She went on her way, trusting her insurance agent to have gotten what she had requested, which was the same insurance coverage that she had before.
Mr. Levine, you make a strong argument, but as Mr. Hassett points out, both here and in his briefing, the statute says selection of limits or rejection of coverage, et cetera, shall be valid for all insureds under the policy. So how do we square your argument with shall be valid?
Sure. The beginning of that statute talks about insurers. And that's what we're talking about, is an insurer. This is valid for the insurer. The insurer has no liability here. We haven't even sued the insurer for UIM coverage or anything like that, because under Talent, Blevins, Ballesteros, that line of cases, there would be no chance of it. But here, the insurance agent owes a duty to our client to make sure that they got the insurance coverage that they asked for. And I'll reference back to that footnote in Ballesteros that you were talking about with opposing counsel a little bit earlier. Tort claims weren't covered in that opinion. That's what this is. This is a tort claim. I asked for UIM coverage. I didn't get the UIM coverage. I will say there's no allegation here of outright fraud. And I will give you that one. But what did happen here is that somebody didn't get what they asked for when they should have, according to the experts. So it is a tort claim. It is carved out by Ballesteros in the footnote, and it does allow us to present a claim for liability.
Well, to be clear, though, the Ballesteros footnote simply said we're not deciding that, right?
That's correct. They said that they're not deciding it. That question. Now, what I'm looking at is traditional tort principles. We have standard of care. Was it breached? Was there a damage? We have a statute that talks about an insurance company, and we have a whole line of cases that talk about insurers. What I'm not seeing is anything saying that an insurance agent's duty of care is absolved once they get this waiver form. Ballesteros doesn't talk about it, but do we have to have somebody who says that a tort claim has to be able to be presented? No. We have standard principles that tell us that. In Darner, there's a duty of care. That's what we have that governs this situation.
So really, the shall be valid, one way to look at that is from the insured's perspective. You're looking at it from the who is it intended to protect, and because the statute uses insurer, not agent, it's only insurer. But couldn't you also look at that and say, well, it shall be valid by all insureds under the policy, sort of to the world, unless there was fraud in the inducement or something that we just aren't presented with here.
And if the legislature wanted it to be read that way, they certainly could have drafted it to be read that way. But what we have here is we have a statute that deals with insurers. It shall be valid, but it's for the insurer, not an insurance agent. And that's why I'm saying the statute doesn't apply here.
The statute then would, under your theory, your view, it's the insurance company that has to provide on their own the form. I'm still having a hard time making that link. If the insurance company only provides the form through an agent, what has the legislature accomplished? And I'm sorry if I've already asked that, but your best shot at what did the legislature accomplish by through this statute if we still have to litigate everything, even though a form has been provided to the insured?
The legislature, by passing the statute, got insurers immunity from a lawsuit where the insurance agent makes a mistake. That's what they did by doing this. Thank you.
Well, I'd like to thank both of you for your briefing and your argument today. We'll take this matter under advisement and issue a decision in due course. Thank you very much.